What are the key points that any doctor or healthcare professional practicing in India should know about the Digital Personal Data Protection Act 2023, and what are the penalties and punishments that a doctor can face? Section 3 defines data fiduciary and data principal. All healthcare providers are considered data fiduciaries. Section 6 mentions the consent requirements. Explicit consent is required for data processing which is related to the patients. Section 11 mentions the rights of data principals. Patients have the right to access, correct, and erase their data. Section 13 mentions the grievance redressal mechanism and establishes a process for addressing complaints. Section 16 mentions the penalties for non-compliance. It specifies fines and penalties for violations. The Digital Personal Data Protection Act overlaps with the Information Technology Act, 2000 Act, and replaces Section 43A of the IT Act, which dealt with reasonable security practices and procedures. Also, it replaces the Information Technology, Reasonable Security Practices and Procedures, and Sensitive Personal Data or Information Rules 2011. The fines imposed by this Data Protection Act are: doctors or hospitals can be fined up to rupees 250 crore for non-compliance. For less severe violations, the minimum fine is rupees 50 crore. The Data Protection Board can impose urgent remedial or mitigation measures in the event of a personal data breach. In addition to these, in cases of gross negligence or intentional misconduct, criminal liability may apply under the Indian Penal Code. The DPDP Act applies to all healthcare providers, including individual doctors, clinics, hospitals, and other medical institutions that handle patient data. Email on drlawyerofficial@gmail.com.